the new FDCPA rules November 30th. So, it's almost October 1st. So basically 2 months and we're doing this. And so let's talk about why do we want to look at these rules? I was talking with my law partner. We've been practicing law for, I don't know, a ridiculous number of years together. And we were talking about these new rules and we were saying these will really be the most significant changes in the law at any one time since we've been practicing law. Now, there have been other major changes, but I think these changes will fundamentally alter debt collection, and the FDCPA, so Fair Debt Collection Practices Act, will alter FDCPA litigation. I expect there to be just a ton of violations, lots of violations by these debt collectors. And so, they'll violate the law for a couple of reasons. One, because it'll make them money. Number two, because they assume you won't know that they're violating the law. Or if you know it, you won't take any action. And that's what we are trying to do with this workshop and the workshops to follow, is to really understand these changes so that we can know when these guys are breaking the law and then hold them accountable. Because nobody should be entitled to take away our peace of mind, our peace, our tranquility at home because they're violating the law. So we need to go after them when they do that. So here's what we're going to learn. We're going to talk about where to find the rules. That may seem like a very silly thing, but because these are regulations passed by the CFPB, it's not just the easiest thing to find. A lot of times if you Google it, what you'll come up with is about a 600-page PDF that you have to combine with this other PDF and sort of figure out, well, all right, here are the rules here, but were any modified in the second PDF? I'm going to show you a very easy way to find the rules and the official commentary. And we'll just look for a moment how they're organized. It's different than how it is in the FDCPA. And then we'll just look at these rules. And I had originally thought, well, I'll put them up on the slides, but I don't think I'm going to do that. I think we'll just go through the actual section. And so we want to learn each section, and we'll go through maybe 1 or 2 sections today, and then we'll carry on with this series. But then when we get to the end, that's when I want to spend at least one workshop, maybe 2, where we just go through scenarios. And so as you think of ideas, write those down, and you can either put them in the comments or you can email them to me, and I'll incorporate those as little scenarios where we can then all of us collectively look at them and say, okay, what do we think about this? Because as we learn these rules, at some point we have to say, all right, this is what this rule up here says, but how does that fit with this rule down here? How do these things combine? And so that's where I think the real learning will take place. But we've got to just go through the text of these rules first of all. And so real quick, I think most of you know who I am. My name is John Watts. I guess I didn't say that. I'm a consumer protection lawyer. And I've laid out a couple of reasons on these slides. Basically, it comes down to I've been doing this a really long time in a very practical sense. So I've been suing debt collectors in state court and federal court. And matter of fact, this morning we had a hearing in front of a federal judge on an FDCPA case. So this is not some theoretical or, I go around the country and teach workshops and I haven't ever done this, or I'm a law school professor who's never practiced law. No, this is what I do. This is how I feed myself and my family. Okay. And so I train other lawyers. I have a lot of information for consumers. Obviously, you guys are getting some of this today. And, we've had multiple jury trials in federal court related to the FDCPA. So anyway, hopefully that's enough for you to say, well, maybe I'll stick around and listen to this. So we're going to look at these rules, how they're organized, and then we're going to go directly to the website to look at these rules, because I want you to see how they're organized. And it's pretty neat. There's the rule, and then there's some official commentary. And I'll talk to you about that when we get there. So let me stop the slide presentation for just a moment here. And let's see, Warren says, good, you're back. Hey, it's good to be back. I've been buried in court. And yes, there are tons of violations, I think, that are coming. So let me share a couple things with you guys. Let's see. This if you click on, we'll take you to the CFPB page, the website where you can find these rules. And let me go ahead and share my screen so you can get there. And if you miss this, if you're maybe on a phone or watching this or not watching this, listening to this while you're driving, just go to the CFPB website and you're looking for its rule 1006. And if you put in the FDCPA regulation F, you'll find it. But that little link that I shared will take you to what we're looking at on my screen. So the reason I want you to see it this way is, again, it's different than maybe a congressional statute. Like we could type in the FDCPA and that comes up very clearly. With these regulations, sometimes it's a mess finding it. Okay, so this is the way to go. And you'll see this warning here that says this version is not the current regulation. You're viewing a future version going to effect November 30. So this is just telling us, okay, these are the new rules coming. And if you'll look down the left-hand side, you see a subpart A, and it's 1006.1 to 1006.2, and there's a little plus button. And that will just expand it, and then those are hyperlinked. And so all of these sections can be expanded here. And so we've got some model forms, we've got all their sort of official interpretations. And let me talk about that for a moment. So we have laws made by Congress. Then Congress delegated to the CFPB, Consumer Financial Protection Bureau, to the ability to update the FDCPA. And so they've done that. And so these regulations, Regulation F in this case, and if you've ever dealt with like Truth in Lending or RESPA, you might remember hearing about like Reg X or Reg Z. It's just Regulation X, Regulation Z. This happens to be Regulation F. So maybe it will be known as Reg F at some point. But these are, definitely the law, okay? And so I do not expect judges would disregard this. The official commentary is very, very powerful. It's not absolutely binding on the judges, but very few judges are going to go against what the CFPB says about their own regulations that they've created, okay? So they say, hey, here's how we interpret exactly what we wrote. So not saying a judge has to follow that, but they likely will follow that. So let me see here. We've got Lance, hello from Florida. So, hey, Lance, good to see you and hope you are enjoying the fine state of Florida. So let's go ahead and look here at section 106.1. We're not going to spend much time on this. I just want you to see a couple things. So as I mentioned, this is known as Reg F or Regulation F, and they give you sort of their authority. In other words, hey, CFPB, who gave you the power to do this? Well, they say, well, the FDCPA, the Dodd-Frank Wall Street Reform and Consumer Protection Act, and the e-sign Act, which deals with electronic signatures. That's not so important for us. I want you to look at this purpose here. Let me see if I can make this a little bit bigger here. All right, so hopefully this is a little easier to read. So looking at the purpose. So this is important, particularly when we're suing these guys, because they'll come into court and say, Judge, there's not a problem with abusive debt collection. This FDCPA thing, it's outdated. Maybe it was true in the 70s, certainly not true now. And there's no reason to give any serious consideration to this. Well, here we are. These will be effective November 30, 2021. And the CFPB says, look, this part carries out the purposes of the FDCPA. So what are the purposes? So we've got, number one, eliminating abusive debt collection practices by debt collectors. Now, if that wasn't happening, we wouldn't need that as a purpose, but it's still happening. And the FDCPA still says that there's abundant evidence of abusive debt collection. So what's the second thing? So you think number one is to protect consumers, right? Stop these abusive practices. Look at number two, ensuring that debt collectors who refrain, in other words, they don't do abusive debt collection practices, are not competitively disadvantaged. So It's like if we're playing a football game and you have 11 players on the field and I have 13 players. Well, that's not fair. Okay. I'm breaking the rules. You're following the rules. Well, the debt collectors that violate the law, they're taking shortcuts. They're being abusive. They're lying. They're being unfair. And by doing so, that is a competitive disadvantage to the honorable debt collector. So I was making a closing argument one time in federal court about this. And I was saying to the jury, look, you need to hammer these guys because what they're doing is so unfair to the honorable debt collectors. The debt collectors that are saying, okay, let me follow all these rules, make sure I, dot every I, cross every T. The guys that break the law, that's unfair to the ones that are actually following the law. And so the CFPB is recognizing this. Excuse me, one moment. All right. And then excuse me, the rest of this is consistent state action. Again, protect consumers. And so these new regulations are really designed about communication. Okay, so debt collectors have been saying, can we email? Can we text? Can we send you a friend request? Can we send you a direct message on Twitter or Instagram? And this is what Regulation F is designed for. So we talk about certain features of debt collection are disclosed fully, accurately, effectively, permits consumers to understand the cost, benefits, risk associated. And so we're going to see this mainly deals with communication. So let's go to the next section here. Now, this is definitions, okay? And if you're like me, you don't spend a whole lot of time on a weekend saying, let me just peruse the dictionary, okay? So we see definitions a lot of times. It's like, just sort of gloss over that. It's actually critically important to understand. If we want to know what these rules mean, we have to know what the words mean. If we don't know what the words mean, we can't know what the rules mean. So let's look at these. Some of these are very similar, unchanged from the original FDCPA, but there are some new ones that are pretty important. So when we say the Act or the FDCPA, we simply mean the Fair Debt Collection Practices Act. Then we have something called attempt to communicate, and that's new. But what I want to do is actually drop down to subsection D, communicate or communication, because we really need to know what that means before we know what an attempt to communicate means. So it says conveying of information regarding a debt. So let's just stop there. It's somehow transmitting information about a debt, and this is directly or indirectly. So it could be directly to somebody, or it could be, well, let me give this to your neighbor or somebody else. And it says to any person through any medium. So medium is just, are we talking about a text message, a voicemail, a letter, a billboard? Like, what are we talking about? It's any medium. And so they're making this very broad so that, if there's some new form of communication in 5 years, that would be covered by this. Okay. And then I want to show you this. See how if you use this version, it has the official interpretation sort of built in. You just click on the plus button and then it starts telling you about this. So, we say here, any medium. Well, what does that mean? Well, they tell us here, any medium. And so they say a communication can occur through any medium. Well, what does that mean? Includes any oral, written, electronic, or other medium. I mean, now, I think I learned in school we're not supposed to define a term with a term, but their point is they're saying, I don't care how you do this, whether it's smoke signals or you put a big sign on the moon, whatever it is, okay? Any medium counts. And they say, well, let us give you some examples here. Because there's an argument that debt collectors made. I thought it was kind of silly. But they would say, well, if we talk to you in person, that's not communication. Communication is only by phone or letter. But they say, look, communication may occur in person, by telephone, audio recording, paper document, mail, email, text message, social media, or other electronic media. So however it is, it's as broad as it can possibly be here. Now, remember we said, any medium up here, that's the rule. Well, what does this mean? Information regarding a debt. okay? Directly or indirectly. Well, we come down here, information regarding a debt. And so let's look at this first. A debt collector does not convey information regarding a debt directly or indirectly to any person if the debt collector leaves only a limited content message. Now, some of you were with us, I guess it's been maybe a month ago, when we did a little webinar on the limited content message. And matter of fact, let me put that up. If you did not see that, I actually just posted that on YouTube today. And so if you click on this link, it should take you to the YouTube video, and, just pause it and it'll be there when you get done. Or just go to my channel on YouTube. It's Alabama Consumer Protection Lawyers, I think. Or just put in my name and limited content message. It should pop up. We'll address it some more today, but if you want sort of the full deep dive, you can watch that. So it's saying, look, if you use this limited content message, which basically, like, it doesn't say the consumer's name, it can't say anything about a debt, it can't give any hint this is a debt collection call, then that's not an attempt to convey information regarding a debt, okay? Now, let's put that aside. And they say a debt collector who provides marketing or advertising that does not contain information about a specific debt has not communicated, even if they transmit the marketing to the consumer. And their point with this is, look, it has to be communication about the debt. Now, if they just say, hey, by the way, we're selling a weekend training course, well, that's not, communicating about a debt. So it's a little odd. We'll come back to that maybe later on. But so remember this here. Let me just close out this part. Communication, or to communicate, means the conveying of information regarding a debt directly or indirectly to any person through any medium. So let's go back to attempt to communicate, because there's always been this argument. Well, we tried to call, but you didn't answer the phone, so that's not a real call. It's like, well, if you make my phone ring, it's a call, okay? Or we sent you a letter, but you never opened it. Or we sent a letter to your ex-mother-in-law, but she never opened it. So what does that mean? So let's look at attempt to communicate. And you'll see this is very broad language that's used. Any act, all right? Any act to do what? To initiate a communication. Remember, communication is conveying of information regarding a debt directly or indirectly to any person through any medium, okay? So any act to initiate a communication or other contact about a debt, okay? So, and we'll define debt here in a moment, with any person through any medium. So you see that it's any act, any person, any medium, and it says including soliciting a response. So if I do something as a debt collector and I'm trying to get a response back, well, then that would be an attempt to communicate, even if I don't, okay? And then they say, look, an attempt to communicate includes leaving a limited content message. But we'll see that a limited content message, remember from a moment ago, that's not actually a communication. So some of these we have to start putting together. So let's look here at the official communication here. So examples here. All right. And so let's see here. Let's just highlight this one here. An act to initiate a communication or other contact about a debt is an attempt to communicate, regardless of whether the attempt, if successful, would be communication that conveys information. So they're going to give us some examples here. Assume a debt collector places a telephone call to a person about a debt. And then notice this, regardless of whether the debt collector reaches the person, the debt collector has attempted to communicate. Now that just makes common sense. If I'm a debt collector and I call you and you don't answer, I may not have reached you, but I tried to reach you. And so they're just saying, look, this is an attempt to communicate. Now, let's look at this one here. Assume a debt collector places a telephone call to a person about a debt and leaves a voicemail message. They say, Well, regardless of whether the voicemail message consists solely of limited content message or includes content that conveys directly or indirectly information about a debt, the debt collector is tempted to communicate with the person. So when we start thinking, okay, they did something, were they trying to communicate with me? Were they trying to provoke a response back? Well, then it's going to be an attempt to communicate. So let me check the chat here. So yeah, it's a great point from Diana. I hope I'm saying your name right. It says, this reminds me of studying God's word in context. Have to know the meanings of the words used. Absolutely. If you're studying the Bible or any topic, you've got to understand what the words mean. Okay. And it's easy just to pull something out of context that really has nothing to do with it. We need to actually see things in context here. And Maria says, I see a ton of violations too. Yeah. And I don't think we'll get to it this week, but our next session, we're going to get into, I think it's next session, we'll get into like emails and text messages and convenience. And that's going to be really, really interesting. So let me close this out. So now we come to consumer, because a lot of times, but not always, in the FDCPA, we're talking about things done to a consumer. So who is a consumer? Is my ex-wife a consumer? Is my brother a consumer? Is my mom a consumer? My child a consumer? My ex-boss a consumer? What are we talking about here? It says any natural, let me get that to highlight, any natural person, and they can be living or deceased. And then notice this, obligated to pay any debt. So again, very broad, any debt. Now we'll have to define debt here, but that makes sense. If I owe the money and a debt collector's calling me and say, hey, John, I know you owe this money, and then they violate the law, I can sue them. Well, what if it turns out I do not owe the debt? I've seen debt collectors, usually with very inexperienced defense lawyers, they come in, they go, well, Judge, yeah, we did this, but it turned out the plaintiff, the person suing, did not owe the debt. So we could not have violated the FDCPA because there was no debt. And we just point out, well, let's look at the definition. A consumer is a natural person obligated or allegedly obligated to pay any debt. So even if you're wrong, even if you're a victim of identity theft, even if the debt collector is just super sloppy and they are going after you, when you don't owe the debt, you're still a consumer. All right. And then let's look at creditor here. So any person who offers or extends credit, creating a debt, or to whom a debt is owed. Okay. And then it says this does not include any person to the extent that person receives an assignment or transfer. In other words, a debt is sold or assigned or given when the debt's in default solely to facilitate collection of debt for another. So creditor means what you would think it means. Bank of America is a creditor, Capital One's a creditor, your whatever, Toyota Finance or Honda Finance. That would be a creditor. They're the ones that extended the credit to you. Now let's look at debt, because this is really important. And you'll remember what I was saying before about these lawyers would come in and say, well, we didn't violate the FDCPA because there is no debt. This is not a consumer and there's no debt because nobody owed anything. So let us go home. And the judges wouldn't do that. And, we point out it's very simple. Debt means any obligation or alleged obligation. So they may say I owe money, and if I don't, it's still a debt, even though I don't really owe anything. And then it's an obligation or an alleged obligation of who? Of a consumer. So it's not, your neighbor 2 doors down. That person's not a consumer. Now, they might be harassed enough so that they could sue, but we have to, again, follow these definitions. So debt is an obligation or alleged obligation of a consumer to pay money. All right. Well, is this any debt? I mean, just any obligation? No. It's arising out of a transaction which the money, property, insurance, or services that are subject to the transaction are primarily, and that ought to be an important word for us. It doesn't mean exclusively. It doesn't say 100%. It says primarily. Primarily for what? for personal, family, or household purposes, whether or not the obligation has been reduced to judgment. So here's a simple way to think about this. Is this a business debt? Well, then it's almost certainly not going to be for personal, family, or household. Okay. Let's see what the interpretation is here. So right now they're just giving us, sort of this idea about consumer. So they say, any obligation or alleged obligation. Then they say, well, if we look at 106.2E in turn defines consumer to mean any natural person. So only natural persons can incur debt. So, well, what about an LLC? Not a natural person. What about an S Corp? Not a natural person. So a consumer is a living, breathing, or formerly living, breathing, because now they say deceased, but you have to be a real person to be a consumer. And then let's go down here to, let me make sure. Yeah. So debt collector, and this can be a little bit complicated, and we're not going to get bogged down in all the details. Okay. Just understand that this can get a little tedious trying to figure this out, but I'll give you sort of the simple rule for this. Okay. So let me give you sort of my interpretation first. A debt collector is somebody that their primary business is collecting debts that are either they own and they got them when the debts were in default, or they're collecting for other people. And let's just actually jump into this and I'll show you. So there's two parts here. Any person who uses any instrumentality of interstate commerce. Interstate commerce is super broad. I mean, like basically everything in the world affects interstate commerce, according to, what the Supreme Court has said. So if you're using anything interstate commerce, that could be you're picking up the phone, you're sending an email, you're sending a text, you're sending a letter, and they even say, or mail in any business, the principal purpose. You see that again? We saw that when we're talking about debt, that the principally, household, family, that type of thing. So the principal purpose of which is the collection of debts. So if your main part of your business is collecting debts, you're a debt collector. Now, the other option is, or who regularly collects or attempts to collect directly or indirectly debts owed or due or asserted to be owed or due to another. That's going to be more of your traditional collection agency. They say, hey, we don't own this debt. We're just collecting it for the hospital or for the car dealership or whoever it may be. And so here's a simple way to think about it. We ask ourselves this question. I'm not saying this is 100% accurate always without exception, but it's pretty close. If I'm saying, is company X a debt collector? I'm going to say, all right, the first time that they got that debt, that piece of paper, was it in default? If it was not in default, then they most likely are not a debt collector. If it was in default, and I'll define that in a moment, then they probably are a debt collector. If that's their, let's go up here. If they use instrumentality, interstate commerce, or mail, the principal purpose of which is collection of debts, that's their business, or who regularly collects or attempts to collect debts owed to another. Now, what does default mean? You really look at the contract. Most contracts say, here's your due date. If you do not pay by the due date, you are in default. Well, if the next day it's sold, transferred, assigned, whatever to a debt collector, then we would say that person got the debt when it was in default. And so they are almost certainly a debt collector, again, if that's their principal purpose or if their business is collecting for others. So again, it gets a little convoluted in here. And we'll not dive deep into this, but you can certainly read it. And see, Maria wrote in here, attorneys. I think what Maria is asking is, can attorneys be debt collectors? And absolutely, they can. Now, actually, let's go back to this question or to this text here. So let's say you have a lawyer who helps families where somebody's going to a nursing home, and they help preserve their assets. So we call that elder law. And that's what they do. They represent 100 clients a year. And 99 of those clients, they're helping to pay for a nursing home. But one client is the brother-in-law who says, hey, somebody owes me $500. Can you write them a letter for me? Well, we would say, all right, is that lawyer a debt collector? Say, well, did he use an instrumentality of interstate commerce or mail? Well, yeah, wrote a letter, picked up the phone, whatever. In any business, all right, lawyer has a business, the principal purpose of which is the collection of debts. Well, that lawyer would say, wait a minute, 99% of my business is helping families facing a nursing home, and 1% is writing a letter for my brother-in-law, which I greatly regret doing, okay, because he's been sued at this point. Or who regularly collects or attempts to collect. Well, we'd say, well, does that lawyer regularly collect, attempt to collect? And different courts have kind of different standards on this, but this is what we're looking at. So most of the time it's very easy because the collection industry is really consolidated around, usually not a tremendous number of firms in a state. And so these firms will file thousands of lawsuits a month. They're a debt collector. Okay. The lawyers are a debt collector. The law firm itself is a debt collector. All right, so let's go now to limited content message. Again, we covered this before, and that's that link I put up there. But I want to hit this just sort of in the flow of these definitions here. So it says limited content message means a voicemail message, and that's critical. A voicemail message. Doesn't say text, doesn't say email, doesn't say letter. It says a voicemail message for a consumer. Okay. Now, if we didn't, if we said, oh, I don't care about definitions, we'd say, well, I don't know what's a consumer. I guess we're all consumers, right? 300 million consumers in the US. No, we have to know exactly what a consumer is. And then it says that includes all of the content in paragraph J1. So let's just look at J1 and then we'll come back to some optional stuff here. And it says required content. A limited content message is a voicemail message for a consumer that includes a business name that does not indicate the debt collectors in the debt collection business. So if your business name is, Acme Debt Collector, you got a problem because you have to include your business name, but you cannot include a business name that reveals you're in the debt collection business. You say, well, what do I do if I'm Acme Debt Collector? You can't leave a limited content message, okay? Number two, a request that the consumer reply to the message. And then the name or names of one or more natural persons whom the consumer can contact. And then a telephone number. That's the required. So you have to put that. You can't say, well, I'm going to leave out my business name, or I'm going to leave, I don't want, to reveal the names of any of my employees at this debt collector. So I'm not going to do part 3. No, you have to. So let's look at the official interpretation here. So this says limited content message is a voicemail, includes all that content that we just covered, and then some optional content and no other content. See, they're very specific about this. No other content. Any other message is not a limited content message. You're like, well, can it be sort of a limited? No, it either is a limited content or it's not a limited content message. And then they say, if a voicemail message includes content other than the specific items described, and such other content directly or indirectly conveys any information about debt, the message is a communication. So remember, we talked about what's a communication. And I think we can find it up here for communication. It will tell us that, let's see here. Yeah, debt collector does not convey information regarding a debt, which is what you have to do to be communication, if the debt collector leaves only a limited content message. So that's, again, why we have to know these rules. Let's go back to our limited content message. And so they give us an example here. For example, a voicemail message that includes a statement the message is from a debt collector and a request to speak to a particular consumer, that's not a limited content message because it includes more than the required or permitted content. And then it says message for consumer. Remember, it's a voicemail message for a consumer. Okay. So what if the message is knowingly left for a third party? Well, that's not a limited content message. And so they give us examples. This is so helpful. It's why I wanted to go through literally the website here, the CFPB, because I think they did a really good job here. Say, for example, assume a debt collector has a telephone number the debt collector knows belongs to the consumer's friend. So maybe you took out a loan and they asked for some references and you put Bob Smith. And they said relation, friend. And now that debt collector is looking at that and says, this is Bob Smith, the friend. Well, a voicemail message left for Bob Smith is not a limited content message, even if the message includes no more than the content described in the section, because the debt collector knowingly left the message for someone other than the consumer. And then they say other provisions may restrict debt collector from leaving limited content message. So they give you some stuff, and we'll get to that later. And then they say a debt collector who leaves only a limited content message does not violate this requirement to meaningfully disclose the caller's identity. Okay. So they're just saying, basically, if you leave a limited content message with all the required stuff and no more than the optional stuff for a consumer, then you're okay. All right. So we talked about the required stuff, and let me make sure this was, okay. So here's a great example here. So look how literally limited this is. It doesn't say your name. It just says, this is Robin Smith calling from ABC Inc. Please contact me or Jim Johnson, 1-800-555-1212. That would be a compliant limited content message if it's left for the consumer. Now, again, if they're looking at your loan paperwork, Bob Smith friend, they leave that message, they violated the law. All right, so let's go back to the optional content. So they don't have to leave this. They certainly can, but they don't have to. So a salutation, hello, good afternoon. The date and time of the message. So you see how specific this is. In a way you go, well, obviously you can say hello or good afternoon or good morning. No, I mean, the CFPB is saying, look, guys, this is optional. You can do this. We're getting so specific. We're saying salutation, date and time message, suggested dates and times for the consumer to reply to the message, and a statement if the consumer replies, the consumer may speak to any of the representatives or associates. So those are the optional. So let's just go back and summarize. The requirements for a limited content message got to be to a consumer. Number one, business name that does not reveal you're a debt collector. Number two, request that you reply. Number three, you got to name at least one person that the consumer can reply to. And then number four, at least one phone number they can use. Now, the optional stuff is you can say hello. You can say, here's the date and time. Here's when I would recommend you could call us back. And you can speak to any of our people. So let's look at the official interpretation here. So notice this. It says the consumer may speak to any of the company's representatives. But notice what they say. A message that includes a more detailed description of the representative or associate group is not a limited content message. So what in the world do you mean by that, CFPB? For example, a reference to an agent with the credit card receivables group is not a limited content message because it includes more than a statement that consumer, you can reply back to anybody here. So, the debt collectors, again, they'll want to push the envelope here and say, well, I mean, let's put in there, you can speak with anybody in our pre-litigation department, not a limited content. You can speak to anybody in our pre-asset seizure group. You know, not a speak to anybody in our legal department. No, I mean it literally has to just be you can speak with one of our other representatives, but you can't be sneaking in stuff to try to intimidate the consumer. Here's another example. This would be a proper one. So let me just remind you of what the required one would be. You know, this is Robin Smith calling from ABC Inc. Please contact me or Jim Johnson, 1-800-555-1212. So here's the optional. Whoops. Yeah, here we go. Hi, this is Robin Smith calling from ABC Inc. So there's the optional hi, the salutation. Now, and I'll make this easier to see here. So, you know, there we have the salutation. And then here we have the date and time of the call. It's 4:15 p.m. on Wednesday, September 1st. So you can state the date and time. And then please contact me or any of our representatives at 1-800 blah, blah, blah. And today until 6 p.m. or any weekday from 8 a.m. to 6 p.m. Eastern time. Now, the reason that we're doing that is they're saying, you know, you can, let's see here. Let me, get back here. Suggested dates and times, and you can speak to anybody. Okay. So again, they can't use this last part to sneak in the pre-litigation department, the, pre-garnishment department. All right. So again, it's got to be a business name that doesn't reveal it. It's got to be a phone number, and let's just back up. So business name, request that you reply, like please call back. Number 3, name or names who you can talk to, telephone number. That's required. It has to be in there. It's not like you can do the optional instead of the required. No, you have to do the required. And if you want, you can do the optional. You don't have to do all of them. You can do 1, 2, 3, or 4. So salutation, the date and time of the message. Here's some suggestions when to get back with us. And just a statement, you can speak to anybody. You don't have to speak with me. Now, why would they say that? Because remember, the required thing is you have to give a name. So this example, this is Robin Smith. Okay. And so this last part is just saying, look, you don't have to speak with me or anybody I name on here. Any of our folks can help you. Okay. And so that's a limited content message. I think that is going to be a huge area of litigation, because for many years, debt collectors have complained about not being able to leave voicemail messages. And I want to say maybe 4 or 5 weeks ago, we did a webinar where I went through different examples and say, okay, you guys tell me, does this violate the law, not violate the law? So on the one hand, a voicemail message, this is before the limited content, it has to say, this is from a debt collector attempting to collect a debt. But if a third party overhears that, now you violated that part of the FDCPA. So the debt collector say, what are we supposed to do? The answer is don't leave a voicemail message. And so this was something the industry wanted. They said, we want to be able to leave a voicemail message and not get sued over it. The CFPB said, fine, here's what you do. But already the collectors are, whining about this and complaining about this. Oh, we want to leave more information, or, my name suggests that I'm a debt collector. So you're telling me I can't leave this message? And so they're already complaining. They're going to do it. And they're going to say, hey, I can leave a voicemail message that's limited content. I should be able to do that with a text or an email. And that's not what a limited content message is. And so anyway, it's going to be a big deal, I think. Let me look here at our comments here. Kate says, glad they got specific. I can only imagine them contacting the wrong person on social media. Yeah, so many with same names. Going to be a nightmare. Yeah, and we'll get into that maybe in a week or two. How they can reach out on social media. But yeah, if you're looking for me on Facebook, for example, last time I checked, there's a bunch of John Watts on there. Okay. Well, how do you know which one is me and which one's not? And so, think about a collector who doesn't know you from Adam, right? And they're trying to find you. So yeah, the very specific rules that I think will be very helpful to us. Marie asked a great, actually 2 questions here. And I'm going to tell you, Marie, I don't know the answer for certain right now, but let's make sure we get the answer before the end of the series. What about fake names? So normally at a collection agency, if my name is John Watts, I don't leave a message saying, hey, this is John Watts. I might say John, Smith or John Jones or whatever. And so can they do that? Or when it says, go back to our text here, when it says the name or names of one or more natural persons, does that mean it has to be their real name? It's a very interesting question, Marie. And I don't know the answer for certain. I have some ideas, but I want to check on that and see. And then how about abbreviated company names? So a business name for the collector. So, let's take PRA, right? That's an abbreviation. What does that stand for? It's Portfolio Recovery Associates, LLC. So their name is Portfolio Recovery Associates, LLC. At least last time I looked them up. When we sue them, and I think I just sued them last week. Portfolio Recovery Associates, LLC. That's their name. So can they call and say, hey, this is Robin Smith from PRA? I don't know. There gets to be some very complicated issues with licensing. So can you use a DBA, in other words, a doing business as name, sort of a fictitious name? Well, there are certain states that say you have to get licensed in that name. In some states, even individual counties and cities require you to get a separate license for this. So it's going to be very interesting to see exactly how this is handled. Certainly, I think the debt collectors ought to take this very literally. You have to give your business name, not a fake business name. And I would say not a fake name either for the person that's calling or that you can speak with. But we'll see how that plays out. Let's see here. Kate says, sad part, there are many consumers don't know the specifics on this, so companies probably get away with violation. Yeah, that's true. And, what we've been doing for many, many years, if we sort of summarize our mission, is two things. Number one, help consumers understand your rights. And then number two, encourage you to take action. The illustration, sort of corny, but it's true. If you say, well, I want to get from, Chicago to Miami. Well, you got to get in the car. Okay. And first you have to know which direction to go. If you start heading west and you reach the Pacific Ocean, it's going to be hard to get to Miami. So you have to know the map. You have to know the course. But even if you know the best route to avoid every problem from Chicago to Miami, and you never start the car, you never put your foot in the accelerator, all that knowledge is worthless. And we see people sometimes, maybe in the mirror, certainly we see others that they just gather knowledge, more and more and more and more knowledge, and they don't do anything with it. You have to take action. So, certainly share with people this information's out there. I'll put this video on YouTube eventually. Encourage, if you've got friends, family that might be interested in this, sign up for the webinar and just get this information out. And my goal is really so that you guys will understand this in a very good way to recognize that, hey, I think this might be a problem. Now, I'd always recommend going to a lawyer that does this, okay? But it's nice when you can say, hey, I think they violated the law. And, my understanding is here's what the law says, okay? And then you can ask good questions of a lawyer. All right, let's see. Tommy says we call that job security. Yeah. MCM, Midland Credit Management. It's going to be interesting to see. Now we have to sort of look at what is their official name. Now, if the official name is MCM, or is it Midland Credit Management? Is it Franklin Collection Services, or is it FCS, or whatever their initials are? So, all right, let's see. Merle says, can they pretend they are an attorney to scare you if the person is actually working in debt collection but not an attorney? So if somebody suggests or implies that they are an attorney and they're not, then you sue them for that, because that is a false statement. Any false statement, you should look at suing them. So if somebody says, hey, we have a judgment against you, and they don't, you sue them. I remember years ago, some of you may remember this. We had these new bankruptcy laws, and they made some pretty major changes. And I had a client that a debt collector called, and my client said, "Well, I'm thinking about just filing bankruptcy." I said, "Oh, you don't qualify for that. They don't allow you to file bankruptcy after the new rules." Just a lie. Okay. Or you say to somebody, I sued a mortgage company recently and a law firm because they sent a letter saying on a debt that we defaulted on like 15 years ago. They said, just be aware we made credit report on it. I'm like, what do you mean you made credit report? It's impossible to credit report on it. It's way too old. So when they lie about stuff, you sue them for that. All right, let's see. Neil says, would an abbreviated name like PRA and then call displays portfolio recovery be a violation? And Neil, I think that's going to go back to what's their actual business name. Okay. And almost every state, at least the major companies, will be registered as they'll say, this is our name. And so I would look at that. You can look on your Secretary of State. Usually it's called business search, and you can see that. Matter of fact, we will just, let me go. So this is Alabama. So let's look at portfolio recovery and just see. So you can see their name in Alabama is Portfolio Recovery Associates LLC. It's a foreign limited liability company. So if we open this up, their name's up here. And then this is the agent or the person that we served the lawsuit on. Okay. And there's some documents we can get. But for me, I would say, and again, I want to check this out and look at it. I would say if they called and said, hi, this is Robin Smith from PRA, I say, that's not your business name. Your business name is Portfolio Recovery. Every lawsuit, we represent lots of people sued by Portfolio Recovery. They don't sue in the name PRA LLC. They sue in the name Portfolio Recovery Associates LLC. So great question there. Let's see, Alana. Let's see. Said you've called and you didn't receive a call back. So I'm not sure if you mean that you physically mailed it or emailed, but just send me an email or reply back to the email that told you about this webinar, and I'll be glad to chat with you about it. We've had a little bit of turnover in some folks working for us, so it may be that we just missed you there, and I apologize for that. See, Kate says, tell people check out your videos. Well, thank you very much, Kate. And see, Alana cited some of the best knowledge out there. Well, thank you. And that's, my goal with this is to make this very good value. I mean, obviously there's no charge for it, but it's your time. I don't want to waste time, and I don't want you guys to waste your time. So I want this to be very, very useful for you. Let's see. Arin says, off topic, having videos addressing suits or complaints where the balance is higher than the high credit. So I'll just say this, the high credit, well, it depends on what you mean by that. Do we mean the credit limit or the high balance? And so sometimes what happens is, let's say we have a $4,000 credit limit and we have $3,995. Then they drop the credit limit to $3,000. But our balance is $39.95. It looks like we're over the credit limit. Like we, ran up this card over the limit. And there's some things to do with that to make sure the credit report is showing for each month what the credit limit was. Now, if you mean something else, talk to me about that, another time when we're, discussing the FCRA, and I'll be happy to do that. Kate says, double check company or attorney is licensed in your state. Yeah, absolutely. And Tiffany asked, attorney reporting a charge off. I fight back with a counterclaim, and the court date is next year, must be removed. There's no obligation to remove an account from credit report just because it's in litigation. And let's see, Maria, I'll work for you. Well, hey, I may take you up on that. So reach out to me if you are interested in this type of stuff. Let's see here. So let me come back to Scott's question. That's about FCRA. Murray asks, is there a statute of limitation for suing a debt collector? So generally it's 1 year from the violation if we're suing under the FDCPA. So let's go back to our definition because we're basically done here. But a person, it's very, very broad. So remember when we're talking about, for example, a debt collector, I think that's going to be one here. Let me find debt collectors, any person. Well, we might think that means a, human being, right? But again, that's why we study these definitions. A person includes natural person, so a live human being, corporation, company, association, firm, partnership. You get the point. They're saying any body or entity is a person. And then a state means literally a state or Puerto Rico or something like that. So that's basically it for the definitions. I will show you this 106.6. We won't get into this time because we've been going almost an hour here. And but just to kind of give you an idea, we'll talk about, it's going to explain what a consumer is. And then communications with a consumer. This right here, if you want to sort of, get ahead a little bit, check out this section, okay? What is unusual? What's inconvenient? What can you as a consumer say to a collector? Like, do you have any control? Is it, just a light switch that's on or off, like communicate or don't communicate? Or can you control with that dial and say, for example, I only want text messages on the first and third weeks of the month between 1 p.m. and 3 p.m. Can you say that? Can you say, I only want emails sent to me on the weekend, except for the last Sunday of the month? Do not send me any. Can you get that detailed? We'll find out. And then we'll talk about what if the consumer is represented by an attorney? What about the place of employment? Can you call the place of employment? Are you not allowed to do that? How about a refusal to pay? And I think a lot of you guys were on our little master class we did probably, maybe 2 months ago about, there's a debt validation letter, or what I call a request for information, because that's what you're asking for. And you also dispute it. And then you can do a refuse to pay. And how do you combine all those? So they're going to give us a little bit of insight onto some of this stuff. How about communicating with third parties? What about exceptions to that? This is going to be very, very interesting. Reasonable procedures for email and text message communication. Doesn't matter whether, they're, this is going to kate@gmail.com or Kate at whatever, wallstreetjournal.com. It doesn't matter. Maybe it does. Maybe it doesn't. Procedures for email addresses, various communication things here. So really interesting, probably not for 99% of the people in the world, but if you're on this webinar, I assume this is interesting to you as well. So we'll have, I think, a really good session with that. So let me just make sure if I missed any of the comments here, and then we'll wrap this up. And I really appreciate you guys being here. Great comments, questions as always. So Scott says, got an investigation complete letter from a credit bureau. So that'd be like Equifax, Experian, TransUnion, replying to my 1681I certified dispute letter. So 1681I is just the section of the FCRA that says you can dispute directly to the credit bureaus. Their reply was only 2 weeks after they received it. Do I have to wait the full 30 to 45 days? Send my second very detailed dispute letter. Their first investigation was lousy. So let me just give a little bit of context for this. So when you send a dispute letter to a credit bureau, when they receive it, they have 30 days to investigate. Sometimes it can be 45, but normally 30. Well, sometimes they just turn around and finish their investigation very quickly. So once they finish it, in my view, that's fair game. Maybe you want to sue them, maybe you want to do a second dispute letter, but you do not have to wait more time for them. You can say, okay, guys, you told me on this date you completed your investigation. Here's what you still are getting wrong. And I would be very detailed. You might want to include your first letter. Now if there were any mistakes in the first letter, you might want to fix those, note that, but definitely bring up any additional problems. And I would pull my new credit report from annualcreditreport.com. So you have, your original credit report you looked at that created the dispute letter. Then you have the results of investigation. Now pull a new credit report, and that gives you that full picture, and you can see what's changed and what's not changed. So keep us posted on that, Scott. Let's see here. So Murley says, CFPB reports if a creditor debt collector cannot validate a debt, I saw some section that says debt cannot be pursued. Can we ask judge to dismiss the lawsuit if they did not prove they own the debt right after discovery or before discovery? So that would only be for a debt collector, because the FDCPA does not apply to original creditors. And that's only in a certain period of time. There's that 30-day window. This is section 1692G. So really, let me say this. If they violate section 1692G, so they send you a notice saying you have 30 days to request validation, you do that, and they don't respond, and they sue you, the judge really should not dismiss that case because of that. That's not a defense to the case. It just means you can sue that collector. Okay. So when they violate these federal laws, when they're collecting under state law, again, it's not really a defense to the state law claim. It's just you have a very nice case against that debt collector for doing that. Let's see here. Experian hasn't allowed me to get the weekly report since I started disputing with them. Yeah, so sometimes we see that. They might say this is in dispute, or they might not let you do an online dispute if there's already a dispute. I would just maybe try again the next week. If they're blocking you for quite a while, I would just call them and say, hey, what's going on, guys? And, obviously make your own decision. But if they say in the call, please be advised, all calls may be recorded or monitored for quality control purposes, then I would certainly consider recording the call and say, hey guys, why can't I get my credit report? You told me I'm entitled to one every week. Why am I not allowed to get this? And see what they say. And sometimes when they start feeling some pressure, they'll go ahead and sort of open up that credit report again. And then let's see, somebody says about the T-Mobile breach. Yeah, so here's the deal with T-Mobile. We are still looking at that. And in some respects, we're watching what's going to happen with the class actions. Usually those will get consolidated, and we'll see kind of what admissions T-Mobile might make. But our plan is certainly for the folks that ultimately hire us. And right now we're just kind of seeing who is out there, who's been affected by this, and always recommending check your credit reports to make sure you are not the victim of identity theft. But when we're ready to move forward with those, we'll let people know, hey, here's how you can hire our firm. And then we'll move forward with generally what we do in these is we file a few of these as arbitrations. And then we see, does T-Mobile want to talk? If they do, then we'll talk about all the cases we have. If they say, go jump in a lake, we say, great. And we just start filing all of our cases individually, and then they have to deal with those. So we're still looking at that and gathering some information. I'm not entirely sure T-Mobile is being accurate. Some people, they say your social number was not accessed. I suspect some of those will change, that we'll find out that more information was actually accessed. And let's see. So let's see. Diana says, I'm sorry, I'm having trouble here with my screen. How can I get template letters? Just let me know if you mean the letters for disputing through the credit bureaus or through debt collectors. Just respond to one of the emails I sent you, and I'll be happy to do that. So guys, thanks again for being here. I always enjoy doing these. Unfortunately, we end up having a lot of court. And I had court this morning, but fortunately got done in time. And it was one of those where the judge says, we're doing this like tomorrow. And when the guy or gal with black robe says this is when we're doing it, we say, yes, Your Honor. And that's when we do it. So hopefully we'll have a few more weeks here where we can do these, or I'll have enough notice that I can change the date and time. And because I really want to get through this series of these, Regulation F, because it's just so valuable. So you guys have a fantastic rest of the day, rest of the week, and I'll see you guys next week. Okay. Have a good one. Bye-bye.